What were you saying? Oh, do they start? Okay. And do they start the timer also? Hi. Do you want to, like, how does it? Yeah, I mean, oh, am I on? Hi, you guys. No, I don't know. I'm just waiting for you. Go ahead. Okay. Hi, web people. Okay, so shall we go ahead and start our discussion? Welcome back, you guys, or welcome those who weren't here before. My name's McKelvey. I work for the BBC, and I'm very happy that you guys are here today. And we have a timer, so we're going to stick to it. And I was also very happy to be invited on this panel, which I understand is the last but the most important panel of the day, yes. At least according to Meg, who invited me to be here. And the name of the panel is Earning Back the Trust of Digital Natives. And I do believe that she's right about its importance. The panelists up here today are Zach Goldman, who's the Executive Director of NYU's Center on Law and Security, Aaron Hiller, who's the Minority Counsel for the House Judiciary Committee, and Leah Shanley, the Director of CommonsLab here at the Wilson Center. In 2010, Leah was a postdoc at the Mapping Science Committee of the National Academy of Sciences and has won many awards and honors, including a Ford Foundation Forestry Fellowship, which sounds really fun. Aaron Hiller is a graduate of Georgetown University Law School and also of University of North Carolina, where he earned degrees in both biology and philosophy. Mm-hmm. Before becoming Executive Director of NYU's Center on Law and Security, Zach Goldman worked for the Defense Department and for the Treasury Department and the Office of Terrorist Financing, which I assume means tracking it or fighting it, not in support of it. They will talk about the NSA and the digital generation, and they will also be looking into the future. On a personal note, I've been reporting on the Snowden story over the past year, writing about the NSA as well as about him and his new life. Maybe you saw my seminal work that came out shortly after the story broke, What to Pack When You're a Fugitive. Today we know a lot more about Snowden and the NSA, and however you feel about him and the fact that he took the documents, he has been enormously influential in the debate over surveillance. I'd like to start out by asking our panelists to make a few remarks, and then we'll have a conversation about surveillance.
So thank you very much, Tara, and thank you, Meg, and Congresswoman Harman at the Wilson Center for having us for a very stimulating discussion today. So I wanted to just start and make a few very brief points, some of which draw on what others mentioned this morning about issues and challenges that I think will be persistent for the intelligence community in the United States in trying to win and to regain the trust of the digital natives. And Mike Leiter mentioned this morning that the community that's been most sort of outraged about a lot of what's gone on is the community in Silicon Valley, the community of engineers and activists around tech issues. And this is the community that's going to be, in many respects, driving the conversation on these issues for the next several years. And so it's important to try and, for the intelligence community's sake and for the sake of our broader interests, to re-engage. And so I wanted to start by just saying that the first issue, which seems so basic that it's almost obvious, is the question of what is privacy. But it's really foundational to all of the issues we discussed today. It's clear that the way we understand privacy has changed dramatically in the last 10 and even in the last 5 or 3 years. And today, the Constitution provides protection via the Fourth Amendment to information over which we have a reasonable expectation of privacy. The case that articulated that standard was decided in 1967, but cases that came later basically exempted huge categories of information from the definition of what's protected by the Fourth Amendment. And in the 70s, when these cases were decided, it wasn't clear to the court the expansive scope of this carve-out called the third-party doctrine, which basically says that records that individuals hand over to private companies no longer carry an expectation of privacy. But it's clear today that the sensitivity, the privacy, and the volume of records that are not constitutionally protected is enormous and cuts to some of the core questions how we conceive of privacy today. And so it may be time to rethink the third-party doctrine, but at this, and the Supreme Court has, in sort of concurring opinions, suggested that it may well do so. But doing so comes with large costs and big problems. There are 18,000 state and local police agencies in this country, for example, which rely to a large measure on the third-party doctrine for a lot of the work that they do. And so any rule that was to replace the current state of the law would have to be pretty easily understood and easily administrable. So that's one question, kind of foundational issue: what is privacy today? Second issue is, how do we conceptualize the harm? So again, American law traditionally understood the harm to be the collection of data in the first instance. But as others have mentioned today, collection is ubiquitous by government, by private sector actors. And so there is an increasing shift, including in a big data report published by the White House last month, to an understanding that one of the real location or the real conceptualization of harm today is in the analysis, dissemination, and use of data. So we're really at the very beginning stages of thinking through in a meaningful way how to regulate and how to even think about regulating the so-called back end of data use, the analysis, retention, dissemination, and use, as opposed to the front end collection issues. Third issue is, where does the harm come from? So it was, again, traditionally understood that we're more concerned about data collection by the government than by private companies. Of course, only the government can subject you to a tax audit, can deny you entry at a border, can put you on a no-fly list, and in extreme cases, obviously, can arrest, prosecute, and deny you your liberty. But it's also becoming increasingly clear today that private companies with almost no regulation use data that is freely available to meaningfully affect people's life choices. And whether this is something trivial, like making discounts available to people who companies think live in high-income neighborhoods, to something more profound, like affecting the terms under which people can obtain mortgages or insurance or jobs, which should be obvious to any college student with a Facebook account, it's again becoming clearer that harms can come, real meaningful harms can come from the private sector as well. And then two final points to which others have alluded this morning as well. The first is the distinction between U.S. persons and non-U.S. persons. This distinction is a core feature of American law, and framed in the abstract, the idea that the U.S. Constitution protects American citizens and not foreign citizens seems pretty ordinary. And indeed, it would be pretty odd if the U.S. government took the position that its Constitution protects people in places from Bolivia to Zaire, including Iran and China in the middle. But the implications of this pretty mundane principle, I think, were pretty jarring to non-U.S. persons, and the implications are basically that non-U.S. persons have almost no rights and no protections under U.S. law. And I think that people, particularly in Europe, were a little bit shocked to find that they are treated functionally as North Koreans. And so I think that this is an issue that will only grow in importance. In Europe, again, in particular, data privacy is conceived of as a fundamental right protected by the European Convention on Human Rights and a slew of other legal instruments. And so for the digital generation, particularly on the other side of the Atlantic, basing such profound questions as the protection of human rights on something as arbitrary or even anachronistic as the nation of one's birth is I think strikes them as odd. And this is having a real effect on US-EU relations, negotiations over data sharing agreements in the law enforcement context. It's something that the US and the EU have worked through before in the terrorist financing tracking program, which is a very successful program negotiated between the EU and the US in 2010. But there are many reasons why that was sort of an exceptional circumstance, and this is going to be a pervasive issue. And the final issue I wanted to just touch on is the problem of secret law. I think it's obvious to many that the intelligence community operates in secret and needs to do so. It's also obvious to many that the intelligence community tends to overclassify things. But I think the real structural and strategic problem is legal authorities that are interpreted in secret in ways that are not necessarily obvious from the face of the statute. And I think that, particularly with regard to the telephone metadata program, has been the cause of a lot of the public consternation about these issues. And so I think it's an issue that the intelligence community is going to have to work through. And as Congresswoman Harman and Bob Litt said this morning, I think if there had been more public discussion about the ability to use the Section 215 authorities for bulk collection, I think that the Congress and the American people probably would have accepted it. And that what was most, I think, unsettling to the majority of people was the fact that a statute that did not obviously permit this kind of activity was nonetheless interpreted to do so, and interpreted to do so in secret. So those are 5 sort of thoughts and issues that I think will be with us moving forward, and I look forward to a discussion more broadly.
Thank you for your remarks. It's very interesting, especially the conflict between Europe and the U.S. over these issues, the way you talked about the distinction between U.S. citizens and non-U.S. citizens, and also just the question of privacy is seen in different ways in different countries. It's not a universal by any means. People have different understandings of it, though I do think you were a bit harsh on the North Koreans. And I would like to ask you to make some remarks if you want, or you can say you don't want to.
Well, I think the importance of the security and privacy issues around government monitoring is very valuable. I will echo my panelists here, as well as panelists earlier, that we also need to be paying attention to the private sector monitoring. All Americans are being tracked by hundreds of data brokers without their knowledge and consent. And as an recent FTC report notes, these data brokers are maintaining information about our age, gender, race, ethnicity, income level, where we live, where we go, what we buy, our political and religious beliefs, our health, our romantic interests, and our social networks. So one of the companies, I think it was Axiom was mentioned, is maintaining, one of them was maintaining over 3,000 pieces of information on each of us. 80 to 90% of Americans are being tracked in this way. This information is being used to segment the population. It can be used for predatory practices and discrimination against individuals, for example, like redlining in the previous century. Few of these companies allow individuals to opt out or correct that information. As the FTC report noted, it's very hard to find out who is tracking you and how to opt out, even if they allow for it. Second, in the earlier panel, I think discussion about coming technologies, Internet of Things, 3D mapping, interior location tracking. Those Internet of Things, those distributed sensor networks are going to be connected to these open social systems, to social media, to crowdsourcing. So we are ready for a revolution. Internet of Things is coming. It's here now. We need to start thinking about not being reactionary, I think as Chris in the last panel pointed out, to every new technology, but developing that overall privacy framework. Meg brought up the issue of baking in privacy, and that's a field called privacy by design, where you find technical solutions to legal questions around privacy. There's questions of who will be able to access the data, for how much. I was just reading an article on Fitbit, right? You're tracking your health, very sensitive information about your health it's tracking, and one of these companies is going to charge you $5,000 for your own data. And then lastly, not just age differences in privacy and country-to-country differences, but I think even within the US, there's this assumption of a reasonable expectation of privacy. As a woman, as a young woman, you may have a different sense of privacy than a young man, because it's not just about privacy, it's about personal security, safety on the street. As a Native American, you may have a different sense of privacy than a white, right? Because you've got a sense of cultural differences, of protection of that community, and vulnerable populations have interest in their well-being. So I think we need to look at all those issues. I think Chris mentioned that it's not just legal, it's not just technical, but it's these social cultural issues as well. What are the impacts to different communities within the US?
Thank you very much. Please.
I should start with the standard disclaimer that anything I say here today is my opinion and mine only, and doesn't belong to my boss or the House Judiciary Committee. But if you like what I say, then Mr. Conyers can take credit for it. That's fine. I've spent the better part of May negotiating the legislation that the House passed now a week and a half ago. And as I have come back up to the surface world and started my recovery, I really think that this is a generational problem. You were talking about the legal architecture.
Can you maybe explain a little
Sure.
bit about what you were doing?
Sure. So the USA Freedom Act was introduced several months ago. My timeline's a little shaky now, by Mr. Sensenbrenner and several of the Democratic members of the Judiciary Committee. Had almost 160 sponsors. Finally, we got the green light from Chairman Goodlatte. We then began negotiations with our Republican counterparts, passed it through committee. Then we had negotiations with the Intelligence Committee. They passed it as well. Then we had negotiations with the intelligence community, and then we brought it to the floor. It's obviously not the same bill that was introduced, and I'm very tired.
Did everybody follow that?
It's, but what that, so here's what I walk away from that. It is the first time since 1978, since the passage of the Foreign Intelligence Surveillance Act, that the House has successfully voted to repeal any aspect of government surveillance, domestic surveillance. It's so easy to ratchet it up, just a little. The political incentive is so easy. Every once in a while there's a problem and you need a new tool to solve it, and you need a new tool to solve it. And there has not been in a generation an opportunity to address this problem. And what that means is the legal architecture you were describing before is completely out of whack with our technology today. The notion that there's a separate set of rules when the NSA plugs its black box in Palo Alto, then they're to get whatever email traffic they want to see, as opposed to when they plug their black box in Dubai or London. I mean, that's archaic. The same email bounces, my email to you bounces all over the world. But the rules were written when it was literally rotary phones, and I mean, it makes no sense. The framework doesn't make sense on our technology today. And we have a woefully inadequate legal structure to deal with that problem. It's a long-term problem to solve. It definitely is a long-term problem to solve. And the bill that the Senate is considering now, that the House considered before the break, only deals with one very small piece of it. It deals with domestic bulk collection. That's really it. There are far bigger problems out there. I think at some point we're going to have to deal with the geographical distinctions that made sense in 1978 but no longer make sense. But at the end of the day, I think the question is whether this is our generational moment. This is the shot that our guys, that my team gets. We get one shot and then we're not going to talk about it again for 30 years. Or is it going to be a sustained political effort over time to do what really needs to be done and update this infrastructure piece by piece?
I hope it's not a one-shot deal. So you have different perspectives here, from people, someone who is working on the laws themselves and how they'll be changed and how policy will be affected by the new surveillance technology, and also someone looking at the legal architecture, and then we have the research into what the data can mean for you. So one of the questions that I have for our panelists is about counterterrorism and social media and the digital generation. You've been working on some research that tracks Al-Qaeda and social media and how terrorist groups use social media. I'm wondering if you can tell us a little bit about that, and also what are the implications for the use of social media or fighting terrorism and for the digital generation.
Okay, so it's not just Al-Qaeda. It's a broad range of terrorist groups and bad actors. In Mumbai, the terrorists used social media to coordinate their activities and communicate back with Pakistan. In Assam, India, doctored photos were sent, text messages were sent through people's trusted networks, spreading misinformation, creating panic, mayhem, resulting in riots. The AP Twitter account was hacked by the Syrian Electronic Army. Posted White House bomb.
The BBC too.
The BBC too, right. And so the stock market takes a huge dip that day. So we're seeing more and more of these uses of social media, of Twitter, YouTube, Facebook, etc., to recruit and radicalize, to coordinate their activities, to get situational awareness, to spread propaganda, to incite panic and undermine stability. Essentially, it's large-scale hacking of human behavior. So DARPA's looking at this, Office of Naval Research, some research universities like Carnegie Mellon, but I think there's been little attention paid to this issue. So we just recently put together an interactive timeline, which you can find on the Wilson Center's homepage, begins to show some of these major events where these tools are being used. We don't have a good assessment of the vulnerabilities. The best practices for addressing these vulnerabilities either don't exist or are outdated. And the government doesn't necessarily have a good handle on the legal framework under which it can operate to monitor these systems and to address these risks. And particularly after Snowden, they're kind of gun shy, right? Because there's a lot of suspicion now of this surveillance. So it makes it a difficult climate to address these threats.
And another question I'd like to ask our panelists is about attitudes towards surveillance and privacy. The polls show that the digital generation thinks that Snowden did the right thing. The polls also show that people over the age of 65 do not think that he did the right thing. So I'm wondering if you can describe some of the differences and what their implications are for policy and legal aspects.
The problem of Edward Snowden is a very thorny one. I think that there's a lot of, is he a hero or is he a traitor? And it's obviously a more complicated problem than that.
So which one?
Exactly.
Yes.
What matters to me about what matters to me about Edward Snowden is that he provided us with an opportunity to say out loud some things my members had been saying in private for a very long time, and felt that they could not say out loud.
What do they say?
Well, you've seen a lot of it. I mean, we've had objections to the Patriot Act, to how it has been applied. The members who have had the opportunity to take the briefings have objected in the briefings several times. I think that's all been widely reported at this point.
Can you tell us anything that it hasn't been?
No, I cannot.
I'm just kidding, go on.
But the final disposition of Edward Snowden makes not one bit of difference to where this debate is going. I really and truly believe that. I don't know. At the end of the day, I don't know. I don't know.
In what sense do you mean that it doesn't have an impact on the debate?
Because we can have a very thorough policy debate, and have been having a very thorough policy debate, without his name ever being mentioned. It is.
Don't say his name at all.
Yeah, it is. I mean, it's the event that obviously precipitated this. But if it wasn't him, it was going to be something else. I do not believe that our government could have kept this secret forever.
I see what you're saying. I see. That makes sense. I understand. So in other words, Snowden had some good effects because it allowed people to talk about things they hadn't been able to before, but this was overdue anyway.
And he has, absolutely, I think that's a fair characterization. And he appears to have committed a crime with advanced knowledge that what he did was a criminal act. It's, however you feel about the ethics of that makes it very complicated for members of Congress to touch.
That's true. So hero or villain, Zach?
So I think the conversation that the nation is having about the scope, the limits, the purposes of surveillance and the resources that should be put behind it is clearly an important conversation. And I agree that some way or another we probably ultimately would have had this conversation anyway. David Sanger was here this morning. What became the 702 program was discussed in the New York Times in December of 2005.
Tell us again what the 702 program is.
Section 702 of the Foreign Intelligence Surveillance Act broadly allows the government to collect either telephone or internet content if it has reason to believe that a party to the communication, the target of the communication, is outside the United States and is not a U.S. person. That provision of the Foreign Intelligence Surveillance Act was adopted in 2008. A predecessor statute was adopted in 2007. And the program itself was adopted under effectively Article 2 constitutional authority a month after 9/11. But that eventually came out. There was a broad public discussion. There were 2 statutes that were adopted that embodied the shift that took place right after 9/11. And we've had more or less a stable legal architecture since 2007. Edward Snowden could have had that effect. I think what's really interesting to think about is that the vast majority of the discussion of these issues has really revolved around 3 or 4 programs or issues. The 215 program, which is the telephone metadata collection program, the 702 program I just described, a few other collateral issues like the trade in zero-day exploits that was discussed earlier today, and issues about collection overseas like Angela Merkel's cell phone. If it had been Edward Snowden's objective to produce a debate about those issues, he could have leaked a dozen or two documents and gone home. He apparently stole, I've seen estimates as large as 1.7 million documents and as low as several 100,000 documents. And so to me, somebody who does that and then gets on a plane to China and then ends up on Russia is somebody whose intention is simply to do damage to the United States. I'm not implying that he was under the control of a foreign intelligence service agency. I have no idea whether that's true. It may or may not be. But I do not believe that he had the best interests of the United States at heart. I think if that had been the case and the only thing he wanted to do was provoke a discussion, he could have gone about things in a very different way.
That's interesting. And what about you, Leah?
Well, the subject of this panel was the digital native, so I did an informal poll of my research assistants who are all in their 20s.
Informants, right?
Informants, right. And I think the reaction was mixed, versus some felt he was heroic in his actions and others felt he was reckless. I do think that they said it did raise their awareness that what they post is there for all to see, that they are being tracked. And while they may not pay as much attention on a daily basis to their privacy, they don't want to see a national tracking system or authoritative control.
Yeah, I mean, I understand, in some of our emails earlier, there was discussion about whether or not we should discuss Snowden, but this is the reason we're having the conference, so I figured that it seemed relevant. I'm wondering if you panelists can talk about the question of privacy and what it means to either different generations or to different cultures, different lands, whatever.
Sure. I think generational probably states it too broadly. I think having finished college just as Facebook was hitting, was a cool thing to do, I have a vastly different view of privacy than my little sister does, who graduated a decade after me. She surveils herself far better than the NSA could ever surveil her. And it's there for the world to see. Sorry, Rachel, if you're watching. I think it's clear that there has been a vast shift in American culture, a vast shift. And again, our legal framework is wholly inadequate for dealing with that problem.
But isn't it different when you're revealing information about yourself and when someone else is collecting it?
Well, from a legal perspective today, that's probably true.
But even from, just a human perspective, it feels different, right?
Mm-hmm.
Sure. Yeah, I'll take that. But again, so you look at something like the Boston Marathon bombing. The first place that the FBI went was to social media to figure out what these guys were talking about. Right. That can be vastly helpful to the government in a targeted, controlled, rigorously maintained investigation. It can also be really scary if you're a privacy advocate and you know that they can do that with anyone they're interested in.
Right, or also with the Boston bombings example, the social media put out a lot of false leads.
That's exactly right.
It was pretty chaotic at the time. Lee, did you want it?
Well, I would agree that younger Americans, having grown up with these technologies, are much more comfortable with them and are sharing more. But I don't think that means they don't believe in privacy. Back when Facebook came up on the scene, I saw interviews with teenagers who said they were moving from MySpace to Facebook because at the time, Facebook had more privacy control. Now we see them moving to Instagram and to Snapchat because their parents have started using Facebook. And as one of my research assistants says, don't post it on Facebook, otherwise your grandmother will see it, right? And another assistant indicated just your very point. It's one thing for that information to be collected from you. It's another for you to have that control. They want to have that control of which circles they're sharing it with. I also think there's a piece of what they call privacy in public. Right? If I'm having a conversation on the street, I'm not expecting people to be listening in and monitoring and writing it down and posting it around. People on Twitter, kids on Twitter, don't assume that they're being read and watched. They don't recognize or realize that that's happening.
So I think an interesting lens through which to view this discussion is, in many respects, the dialogue between the United States and Europe on these privacy issues. Because I think in Europe, the discussion really is quite different. And I think one thing that both marks the discussion between the United States and Europe and marks some of these generational differences is a difference in what we mean when we talk about rights. And I think in the United States, we generally talk about rights as procedural instruments. People have rights to be heard in the judicial context. You sign up to a service, Facebook or Google or whatever, you click a box that say, I've accepted these terms and conditions. And then after that, it's kind of out of your hands. On the other side of the Atlantic, I think people talk about rights as rights to particular outcomes, to have your data protected, a right to be forgotten. These are rights to particular outcomes. And I think that way of talking about rights, governments have obligations to ensure particular outcomes, to ensure, Joris alluded to this earlier in the discussion, to ensure that data is protected in particular ways. It's a significantly different understanding of what it means to have a right to privacy. And I think in many respects, that's when we talk about shifting the locus of regulation from collection to analysis or use, that's sort of what we're talking about. We're talking about changing how we understand rights from the obligation to be able to avail yourself of a procedural instrument to a particular outcome. And I think that is the expectation that a particular generation has grown up with, an empowered generation. And that is the expectation, I think, that will drive what we seek from our political leaders in the years to come as these reform instruments are further refined and as the legal frameworks are thought about in greater detail.
Right, and also just on that note, the idea of privacy is so different for different people that it makes the conversations really complicated and also makes relations between the US and Europe really complicated. For instance, in Europe, you know, they have, like when Europeans come here and I explain to them about credit reports, they're very shocked by it. They can't believe that we would be tracked in terms of our financial history to such a, you know, to the extent that we are. But on the other hand, in Europe, they have topless beaches. So Americans are like, they think it's weird that, you know, women take their tops off at the beaches. So these are assumptions in both places that then they don't match at all. So everyone thinks they know what it means to have your privacy protected, but in fact it's very different. And then also in terms of the surveillance with Angela Merkel in Germany and so on, when the story came out, the Snowden disclosure showed that her phone had been tapped. When I talked to my bosses in London, I sort of didn't think it was that big of a deal. And then they were like, well, Tara, what if Obama's phone was tapped? It just felt very different, you know, depending upon where you are at the time or whether your country is doing the surveillance or not, the perspective changes. So I think this has been a real roadblock for the, you know, figuring out the differences that we have. Another question I have in terms of not Snowden discussion is about the role of the whistleblower, a quasi-whistleblower, and also the heroism, the cult that has developed around Snowden. You guys maybe have heard Oliver Stone is doing a movie now. There's also a movie in the works from another production house based on Glenn Greenwald's book about Snowden. And there's this mythology that's developing. So I'm wondering what the effect is. Is there going to be a generation of whistleblowers that develops? You know, what do you think about the implications in terms of the social realm? Yeah.
Start. So I think he may have some fans, but he won't necessarily have copycats. Manning will spend the next 35 years in prison. Snowden will be exiled the rest of his life. So while there may be an ease of sharing information and a glamorization of this, the consequences of whistleblowing, I think, are still pretty severe and would give people pause. On the flip side of whistleblowing, we're also seeing a rise of surveillance. So we've got surveillance of the government or an authoritative organization surveilling, you know, top down. Surveillance is where the public is observing the authoritative organization or the government. So we're seeing widespread use of cell phones to videotape or tweet out police action and police movements. We're seeing members of the public using mobile apps, do-it-yourself UAVs and low-cost sensors to monitor companies who are polluting our air with benzene. For example, the city of Tonawanda, New York, citizens monitored the air quality, found high levels of benzene, reported it to authorities. Those authorities then took that private company to court, won, and they've reduced now benzene in the air 86%. There was a case of folks, average citizens, using UAVs in Texas They found pig blood in one of the waterways. Again, the authorities came in and took those companies to task for their pollution.
Pig blood?
Sorry?
Why was there pig blood?
It's a processing plant.
Okay.
So I say we're with citizen science, with citizen journalism, and this kind of censor activism. I think we're going to see more of that, observing right back. Also, we've got George Clooney's Satellite Sentinel project, which is using satellite remote sensing to look at Sudan, and that's again more of a public effort. So.
Yeah, I mean, I think that I'd never heard the term surveillance, but I like it. But I think the dynamic, the democratization of connectivity is a very powerful force. I think an equally powerful, but perhaps more destructive force is, if every member of the intelligence community gets to declassify and start talk about, well, their own drone would be a different, I think, problem entirely. But gets to leak documents about programs they don't like. So I certainly hope that that's not a trend we see in the future. And I think you're right to point out that Bradley Manning is going to spend, the rest of his productive life in jail. Edward Snowden will likely spend the rest of his productive life running from place to place. Scared of returning to the United States to meet, in all likelihood, Bradley Manning's fate. What I do think, I hope, will prevent, I think the most powerful thing that could prevent the future Bradley Mannings and Edward Snowdens of the world is the government getting the balance between secrecy and transparency right. And I think that moving forward, greater transparency about the rules, processes, and procedures at a general level that govern what the intelligence community does, I think will help to make the public feel more secure about secrecy, about particular programs, operations, collection activities, and these are the things that really need to be protected in order to ensure that the United States and its allies have the ability to do what they need to do moving forward. And I think the leadership of the intelligence community understands that. And they've done things that are literally unprecedented for an intelligence community. They have created a website in which they post voluminous amounts of declassified material. You have folks like Bob Litt testifying constantly before Congress, doing media interviews, creating offices of privacy protection. So I think if you look in the span of a year, the changes that have taken place, it's hard to think of a 1-year period of time in the entirety of American history where this kind of change, largely for the good, has taken place. And so I think that if we, and this is not a problem that's going to be solved overnight, it's an iterative process that will develop over time. But I think that as the government gets better at balancing necessary forms of secrecy with greater transparency, the incentives and the motivations of people like Snowden, I hope, will evaporate.
Yeah, that makes sense. That certainly has been a lot of change in the past year, and we're going to turn it over to questions in just a second. But I do want to say that the NSA, they've come out with materials that they've been giving to journalists, which shows like a picture of a dark parking lot and things like that. I mean, I think they're trying very hard in the intelligence community, but they might need to work on their PR a bit. I'm wondering if you can tell us a little bit about the Hill. You were saying about the changes that had taken place in the past year and how all the reform is going on, and how is it the digital generation making its impact there?
If you had asked me a year ago if we would have had a vote on the House floor reforming any of this, I would have told you were crazy.
So what's going to happen in a year from today?
I have no idea. Hopefully I'll get some help. Hopefully some of the digital natives will come on and help us staff these issues, because it is definitely an ongoing conversation. One thing, just listening to your comments, that I think is, I would feel like I wasn't doing my job as a staff lawyer if I didn't say, there is no legal definition of whistleblower that fits Edward Snowden.
About that too, right?
Part of the very real problem that we have is all of the technical processes by which a person may become a whistleblower, be protected from repercussions at the office, basically, if you say these guys are doing something wrong. Those pathways are incredibly inadequate. I'm not saying the system is completely broken. There are certainly some ways that you can get, whistleblowers can get information to their superiors or out to the committees of jurisdiction on the Hill, or to inspectors general, who also do a good amount of work. But the cases that we're set up to handle are small. They are not Edward Snowden scale problems. And it is clear that we need better actual whistleblower protection in the law.
Just to make one other sort of follow-up point, the point about Snowden, though, is not that he discovered a particular or isolated incidence of wrongdoing. These were programs that were reviewed by the Foreign Intelligence Surveillance Court, that were briefed to Congress, that had been approved in many different branches of the executive branch. They were simply programs with which he disagreed. And so Aaron's right to say that the whistleblower system isn't equipped to handle that. It's because the kind of wrongdoing he revealed wasn't wrongdoing as traditionally understood.
I think that's fair.
So
that's fair.
So you're saying that reforms need to be done so that it's easier to be a whistleblower?
Absolutely.
Right. And the term whistleblower is thrown around so much, it's hard to know at times whether it even fits the person that's being used to describe. But tell us about the Hill. You said that the difference from now and a year ago has been...
We're talking about it publicly. That's the biggest change.
How's it feel?
It feels really good to tell my mother what this is what I did at work today. I think that the whole dynamic has shifted. The best thing, my favorite thing about the law that the House just passed is, as you said, there should never be secret law in this country. And most of the backlash to the telephone metadata program is not that Americans care that much about telephone metadata, although telephone metadata can be used to say a lot about you. It's that this thing had been going on for a decade and no one ever told them about it. To me, other than ending bulk collection, the most important thing about the USA Freedom Act, as it passed on the floor, is every significant decision of the FISA court will be released to the public within 45 days. Redacted, if there's no way to redact it that makes sense, then the Attorney General and the DNI can issue a summary of the basic steps that they took. We don't need to know the facts. We don't need to know, the public does not need to know which terrorist organizations, which foreign governments are being surveilled, what facts led to the significance opinion. That's okay. The oversight committees are actually pretty good at handling that stuff. Where we have seen a breakdown is on the broader legal concepts. And the public should get to see that. There should not be secret law in the United States, period. And there won't be if this law passes.
That's a really dramatic change.
It's a very dramatic change.
Do you have questions out there? Yes, and if you wouldn't mind identifying yourself in some way and then asking the question would be great.
I'm Gerald Chandler, directed towards you, Aaron.
Yes, sir.
I'd like to understand in more depth the question that came up in the previous panel, how much technology people know. I'll repeat this. I'm Gerald Chandler, and I'd like to know more in depth how much technology people know. You and perhaps even the younger people than you perhaps know and understand the technology behind this. You talked about today is not like 1979. So in your work, other people's work, have you had to educate the members of Congress, the other members of staff? Have they picked that up? Do you think there's a long way to go?
Yes. There's a very long way to go. Not merely in staff educating members, that does take place and should take place more often. I think the last panel was exactly right. But educating me, I am a lawyer. I'm not a technologist by any stretch of the word. I rely heavily on outside expertise as I can get it. If we're dealing with a specific classified matter, I'm basically in the dark on the broader implications of a piece of legislation like we've been working on for the past month. We brought people in on every aspect of that bill that we thought it would be useful to have a technologist give us advice.
And did you guys want to have any? Do you think the lack of technologists is producing bad policies, or is it having an effect?
I think what's really interesting is not, a lack of technologists. I mean, I think that's a very sort of idiosyncratic determination. But I think what is interesting is that lawyers and technologists speak very, very different languages. And so when to Meg's point earlier about baking privacy in by design, when technical systems are engineered, I think the conversation often goes something like this. Engineers say, tell me what the legal rules are, and I'll do my best to engineer a system that adheres to the legal rules. And lawyers say, no, show me the system you've created, and I'll write you a legal opinion about it. And I think getting that dynamic right moving forward is going to be very, very difficult. So one of the most interesting conceptually issues that I think we saw over the last year or so was an opinion that was declassified, written by Judge Bates on the Foreign Intelligence Surveillance Court in 2011, excuse me, in which the systems that were designed to collect data under the authority of Section 702 of the Foreign Intelligence Surveillance Court Act were collecting what he called internet transactions. And this apparently was a new phenomenon in which more or less the intelligence community was looking for particular communications to, from, or about an authorized target. And for reasons that I don't fully understand, they were getting those communications and a whole bunch of other communications as well, many of which had nothing to do with the foreign intelligence target. And you could read this opinion and you can see a judge trying to wrap his head around the way that network engineers design surveillance programs. It was also clear reading this opinion that the engineers that were building the systems, that the legal issues were sort of tacked on afterwards or thought about sort of separately. And I think getting these two groups of people in sync from the beginning is also going to be a persistent challenge that the intelligence community has to deal with for a long time, and will get worse as the technological aspects of our intelligence community probably become more pervasive.
Almost the exact same problem with 215. There's another opinion that was declassified with the telephone metadata.
Explain that. Yeah, go on.
Well, it was the exact same disconnect. The engineers had been doing this, and the lawyers had said to the court that they were doing another thing because they weren't exactly on the same page. And the outcome was that for 6 months they had to go to the court. He didn't trust any of them anymore. He wanted the Department of Justice to come in and supervise the whole process writ large. And they could not access their telephone metadata without case-by-case permission from the court for a number of months.
But it also sounds like if they are in sync, then they could create these diabolical tools, if they have everything in line.
I think when you've got battalions of lawyers in charge, the chances of diabolical evil are almost near zero.
So I'll say there's a movement afoot called Legal Hackers across the country that's bringing together technologists, software developers, and lawyers to work through some of these interdisciplinary issues. There's one based in New York, DC, LA, San Francisco, and the movement is growing. Second, within the Hill, there's several fellows programs, the American Association for the Advancement of Science, for example, that places scientists, engineers, technologists in congressional offices to help provide that advice. I think your question or raising the point of language is huge because science speak and policy speak or legal speak are very different. And then within the science and technologies, you have multiple different disciplines and terminologies, and it's a bandwidth issue. The politicians have to worry about banking and health and security and so many issues, and they have very little time to learn all these languages.
Makes sense. And more questions? Another question? Yeah.
Hi, I'd like to know your opinions on what the public square is going to look like going forward, because there is a definition that the older generation has, there's kind of our generation, and then there's the younger generation. How do we even think about it? How does that connect with CCTV cameras when I'm thinking in my mind the book that Eric Schmidt wrote for Google, and he suggests there needs to be rules in the physical world and rules in the virtual world, and that seems awfully complicated to me, but I just wondered what your opinions were for kind of what the public square will look like going forward.
That's a very good question. I think it's a hard one to answer. I think we'll know more when we see what happens in the Senate with this bill. I really do. The big question mark right now is whether a bill that falls short of what a lot of advocates for change want has a prayer of making it past the usual gatekeepers in the Senate. That's a really difficult challenge for Senator Leahy, and I wish him very well. If you can get that through, then I think you can start having the next conversation. And all of these things are on the menu, right? So what do we do with private companies holding data? That's an ongoing debate. No one's really come up with a good answer for it yet. At some point, we're going to have to deal with basic law enforcement interaction. So ECBA, that's next. And I really do believe that within the next few years, we're going to have to tackle the pretty arbitrary distinction. There's a constitutional matter. I get that the president deals with what happens outside of the United States, and Congress deals with what happens inside the United States. And with the 702 program that was been described, we talk about what transits the United States to. Congress can get at that. But again, the idea that there is a totally different set of rules for stuff that happens to be intercepted outside of the United States than there is for the identical thing that can be intercepted inside the United States is very confusing and not likely to stand much longer.
Did you want to? Did you?
So what Eric Schmidt is saying, Lawrence Lessig said before that too in his book Code and Other Laws of Cyberspace, indicating that we have a legal framework, but then in the internet, it's how things are programmed can determine whether you have 20 people in a chat room that can discuss policy issues or whether you can have millions of people contribute. I think the agencies, the federal agencies and local governments are trying to use some of these new platforms, social media, Twitter, Facebook, and so forth, to engage the public. But the legal framework of which allows them to do that is somewhat uncertain. That we have rules about not lobbying the government, having FACAs set up, using terminology here, federal advisory committees. And so they're trying to figure out how they can use social media and other open tools, digital tools, to engage in that public square discussion.
Yeah, I mean, I think to me, the thing that's most striking, to go back to the question about how we understand privacy, is this craving that we apparently have for online pseudonymous interaction. So people tweet images of themselves or pictures and sort of seek out the reaction of their peers. And so to me, this is what the public square is of the 21st century. And the tricky question is getting government involved in that discussion in a way that's not creepy and and is not stodgy. So, having the State Department have a Twitter handle is fine, but that's not, and it's something they should be doing, and that I think they can do, and that I've seen them do in a very interesting and meaningful way. But to me, that's not enough. I don't know what the answer is, but it's sort of navigating the creepy, stodgy. Those are the sort of boundaries, I think. The government can be nimble and agile, incredibly nimble and agile.
But not the State Department, and not on social media.
No, I love the State Department. No, I mean, that was just an example. I think that all of which was just to say that merely engaging in the discussion, I think, is insufficient, or engaging in one dimension of the discussion is insufficient. I think it's understanding how to communicate with the generation whose expectations are fundamentally different and whose methods simply of consuming information are fundamentally different from the past.
Yes, please, your question?
Maybe you've already discussed this, but it really strongly concerns me about the hacking. There's been so much of that lately. Big companies, no one seems exempt. And the tracking, and it seems so difficult to opt out. You don't know how to opt out, or they won't let you opt out. And yet a lot of valuable information, like on jobs or financial information, is on the internet. How do you deal with it?
Thank you. Guys?
Those are two problems that the Department of Justice has dealt with, I think, this week. maybe it was last week. So a number of the infiltrations that you're talking about hacking comes from overseas. There was a rather notable indictment of 5 Chinese nationals. The government is working it. It's a hard problem. They use some of these tools to get at that problem, which makes it also very challenging to roll them back. I think Ms. Harmon said at the end of the last panel, when you're writing a law, the temptation is to do a list of things that the government should look at, and they can't look at anything that's not on the list. But it's really hard to describe the kinds of things you're talking about in a list of things the government can do and can't do vis-a-vis surveillance. In terms of data security and data privacy, there are at least 3 bills that I know of that are floating around the Hill right now. It seems to me that there ought to be a solution to that. It's one where there are a number of competing financial interests, and so probably is going to take a little bit more time to work that out.
Thank you. Did you guys have anything you wanted to add to that? Yes, please, your question. You want to identify yourself if you could. Yes. Thanks.
Hi, I'm Ann Miles. I'm from National Intelligence University on the faculty there. And I was curious about the title of the panel on earning back the trust of digital natives. And the implication is that there's a difference between the trust level of digital natives and digital, say, dinosaurs, or however you want to, express those who didn't grow up in the digital age. And I don't know that there really is a difference in the trust level, so I was just curious about the title and whether you felt the same. And I'm also skeptical that you can earn back trust with transparency, because it seems to me that a lot of people that are distrustful won't really trust a source that says, we've told you now everything you need to know, right? And you can trust us now. You see that? You see what I'm saying? Yeah. And so people who have decided not to trust are not going to be suddenly, okay, we feel fine now. So anyway, I was just curious about if there's any other things that you can think of that would change those dynamics other than just saying,
trust us.
Trust us. Yeah.
Very good questions. Do panelists want to address?
I think what's interesting to me, I don't see the distinction between digital natives and whatever the sort of converse of a digital native is, as it being a generational issue. I think it's about, I think Mike Leiter, expressed this very well this morning. It's about a particular community of technologists who I think are, and I won't pretend to be a member of this community, so I'm doing my best to kind of channel members of that community who I think are committed to an idea of open, non-hierarchical systems who have a self sort of understanding that collaboration is the way to produce positive sum goods. That's how I would define perhaps a digital native. I mean, it's a totally subjective term, so we could discuss definitions for hours. So I think that there are people within this community who, and so I see that as there's a dialogue going on, I think, between people whose primary interests and backgrounds and concerns, and I probably put myself in this category, come from the national security world, and people who come from this digital world. And I think they just embody fundamentally different approaches to things like public power. And so I think there's an irreducible, perhaps, conflict. I mean, these groups of people, to the extent that I'm caricaturing entire groups of people, may not always agree on everything, but you can kind of get to like a détente status where everybody knows where everybody's coming from. Everybody's kind of fundamental assumptions are basically the same, and we're having a conversation about what makes the most sense. And we'll disagree. I mean, that's what's wonderful about living in a democracy, is that people can disagree in a civil manner and then sort of let the best man win at the polls. But I think that's what I mean when I think about how do you regain trust. You're not going to get these people always to agree with what you think and your approach to problems and even your sort of normative assumptions. But at least let's get the facts kind of right so that everybody's having a discussion on the same basic premises, and we can air exactly what the differences are and what the foundations of the differences are. That's the way I interpreted the sort of theory behind the panel. And the 5 sort of trends or ideas or issues that I started with were things that I thought are important to get a conversation going, to sort of lay a foundation for a common dialogue that I think will never produce answers.
Thanks. Lee, did you have anything you want to
I
add?
actually concur with your comments. Having worked with the open data, open government technical communities, I would say this is a very accurate characterization.
I think we have time for one more. Yes, please. Microphone.
I apologize. I actually have 2 questions. First, I kind of wanted, you touched on ECBA for a quick second.
Sorry, can you identify?
Sure, sorry, Linda. Yeah, also from the Hill. You touched on ECBA for a quick second. I just wondered, what do you think is the appetite moving forward for modernizing laws like ECBA? It's something that we talk about every year, but we don't really get to the nitty-gritty of actually bringing it up to date. And my second question is, now, you mentioned that you had surveyed your research assistants. Do you feel that with sort of the digital natives, that they're able to distinguish the difference between government surveillance and surveillance that's conducted by data brokers or the sort of the commercial entities? And do you feel like there's more trust in one or the other?
There's two basic questions. Do you want to address?
Yours is more interesting.
No, but
Sorry,
if you could do the first one and also
Sure,
no, first translate it.
The Electronic Communications Privacy Act is the law enforcement side to accessing many of the kinds of emails, electronic records that we've been talking about. From a surveillance side, from an intelligence community side of things earlier, that's broadly speaking, that's the law in place. It tells the FBI what the rules are for going to get your emails in a criminal investigation from the company that holds them. Those rules obviously need to be updated. You are right, Linda, that we talk about it a lot and haven't done a lot on it. I would say that the realities of the congressional calendar in an election year at this phase make it highly unlikely that the 113th Congress will tackle this problem. But consensus, I think, is building, and if anything, I think we've shown through the surveillance bill that there is a model for getting in the room and figuring out something that everybody can live with and moving on. It's obvious that it needs to happen. Both communities, both the law enforcement, the federal law enforcement community, and the companies, and the technology, open government folks, all of those people know that there needs to be a solution to this problem, and it's a question of working it out.
Thank you very much. Leah, did you want to address this?
So in the discussions I had with my younger research assistants, who are again in their early 20s, there was definitely the perception or mistrust of government authority, government monitoring. The other thing that was mentioned was employers, worried that their employers were tracking what they said and that they might get fired. I don't know if that meant us, the Wilson Center, or others. But I did not hear anything about concern about private companies, data brokers, monitoring them.
Thank you. And we're running out of time. Would you like to make some last minute comments, things that we can think about when we go away?
I'd just say that the lack of trust, I think it's become cliche to talk about, we have a trust gap, and we need to somehow bridge that trust gap in order to get back to how nice things used to be. We should never go back to how nice things used to be. Never. The reason that things were so nice, as probably everybody in this room knows, is because most of the people who disagreed were not part of the process, very much, in a significant way. Distrust makes for good oversight. Bob Litt doesn't have to be a villain for me to call him in front of the committee and ask questions. We should not always take them at their word. That makes for good congressional oversight of the executive branch and public oversight of the government writ large.
Trust but verify.
Sure.
You guys? Any last minute thoughts for us?
I would say
None.
Trust is two-sided. There is our trust of our government, and government agencies, the ones that we're working with, are working to use these new mass collaboration technologies to better engage and increase public participation in government decision making, not just in data collection, but also in data analysis and ideation. But also there is trust of the government towards us, towards the public, towards Congress. in order for them to feel, I've done a lot of work around government data sharing and releasing of, say, geospatial data or satellite imagery, et cetera. And there's concerns that they're going to get slapped for it, right? That they're not doing enough or they're doing too much, and that by sharing this information that will reveal this, and that the public will react or that Congress will come down on them. So I think that trust goes two ways.
Well, and did you have any?
Trust but verify.
Well, thank you very much. You guys have been a great audience, and that's it.
Thank you.